Hi, everybody. Welcome to our webinar today. Thank you so much for joining us. Before we get started, I just want to thank our sponsors for the Beverly Hills Bar Association, and also Sanaz going to the next screen. So there are 3 different types of memberships that you can have here at Beverly Hills Bar Association. Hopefully there's one that suits your budget, and you get different benefits depending upon which membership you choose. So if you're not a member yet, we encourage you to join, and hopefully there's a membership for you. Okay, Sanaz, you can go to the next page. We're going to thank our sponsors right now. First of all, we want to thank the firm of Hockman, Salkman, Tasha and Perez, tax law firm here in Beverly Hills, for being the sponsor of the tax section. We want to thank them for not just being sponsors, but a lot of the attorneys are very active participants in the Beverly Hills Bar. Okay, next one. Then we also want to thank the family law section for being co-sponsors. SoberLink is one of the sponsors of the family law section. So we want to thank them for their sponsorship. And there's one more for family law. The accounting firm of White, Zuckerman, Warsawski, Luna, and Hunt. I think they do different types of accounting. I think they also do some forensic accounting, and they're helpful. They're very helpful to family law attorneys in their cases. Okay, so now know the next one. And then there's also Family Wizard. That's another sponsor. You just passed it by. Sanaz, can you just go one up so we can see our sponsors? There we go. And there's also Family Wizard, another sponsor. So, and I also want to thank the Bankruptcy section for co-sponsoring this event, since we are from 3 different areas. And Sanaz, if you can go to our bios, I want to introduce the speakers. Wait, there we go. So today we're going to talk about managing tax and bankruptcy issues in a divorce proceeding. The 3 of us, I'm going to introduce, and first I'll introduce myself. I'm Michelle Weiss. I'm currently the program chair of the tax section, and I am the incoming chair of the tax section. I'm a tax controversy attorney at Holt, Slavin and Drapkin. I'm a former IRS counsel attorney, and I have over, that should say 20 years of experience in tax controversy and litigation matters. I help my clients resolve their disputes with federal, state, and local taxing authorities. And I also help with property tax appeals. I do all types of tax litigation. I assist my clients with sensitive voluntary disclosure matters, and I often provide tax counsel for civil litigation matters. I have my BA with all kinds of honors from Barnard College, and a JD and LLM in tax from NYU Law School, and so on and so forth. So I'm a tax attorney. I want to also introduce Sanaz Bareliani from Bareliani Law Firm. She's a bankruptcy attorney. She's a certified bankruptcy specialist with offices located in West Los Angeles. She practices in all 4 federal districts of California and state court. She focuses on both debtor and creditor representation in Chapter 7 and 13 bankruptcies, and case by case in Chapter 11. Although the majority of her practice is geared towards bankruptcy, due to client demands, she does handle debt settlement matters. Sanaz has been nominated a super lawyer for the last 2 years and a rising star for the consecutive few years before that. She is currently on the board of directors of the Women's Law Association of Los Angeles as financial development chair, and the team leader of the James T. King Inn of Court. She earned her bachelor's from USC Marshall School of Business and has her JD from Whittier Law. In her spare time, she loves to cook, spend time with friends, and hopes to return to traveling soon. Limor Mojdehiyazad is a family law attorney with a solo practice in Century City. Her goal with every case and running motto of her firm is divorce doesn't have to tear your family apart. With that in mind, she helps her clients navigate a multitude of family law matters, including high net worth and complex cases, much like the one we have today. Though settlement-minded, she is also a litigator and fights for her clients' interests from every angle. She received her JD from Southwestern Law School and has training with presiding family law judges and at the Strauss Institute for Dispute Resolution at Pepperdine University. She volunteers with the Harriet Buhai Center for Family Law on an ongoing basis and has been recognized as a super lawyer rising star for the last 4 years. So that's the 3 of us. We are going to Sanaz, can you go to the fact pattern? So all of you should have the materials. You should have received them. What I'm going to do today is let you know what we are doing and what we're not doing. So what the three of us did is we came up with this hypothetical fact pattern that we called Whitney's dilemma. And Whitney is a character that's a compilation of all different types of people who have walked through our offices, who have issues that span all three of our practice areas. A lot of times I need to reach out to a bankruptcy attorney, a family law attorney, and the same with them, because the issues cross into different areas. So what we are going to do is go through sort of an issue spotting exercise with respect to each of our practice areas. No area is a deep dive. The idea is to let the attorneys from the other practice areas understand when it is that you might need to reach out. So I'll just quickly go through the fact pattern. And briefly, Howard and Whitney are divorcing after 13 years of marriage. They have 2 children, and Whitney discovers in Howard's financial disclosures that he has not exactly been honest in all of his business affairs and tax filings. And at their last visit, he threatened Whitney that if she doesn't agree to a settlement that was actually much more favorable to him, he would file for bankruptcy and she would get nothing. So Whitney is nervous about this and she wants to figure out her rights and liabilities. Just very briefly, I'll go through this and then we'll each discuss what's going on in these different subparts. But Howard has a business with 10 employees. He failed to file and pay business payroll taxes for all quarters of 2018. The IRS has filed a lien against Howard with respect to Soothme's payroll tax liabilities. And unfortunately, Soothme, his business, was forced to close due to COVID-19 shutdown orders. He also received a PPP loan for Soothme. Howard happens to be Swiss. Before his marriage, he inherited a Swiss bank account from his father. However, he also has some Swiss business operations and business bank accounts that he never told Whitney about. And he also failed to report the income or file any documents with the IRS, any kind of forms regarding his Swiss business and his bank accounts. At the end of each year, Whitney would provide her W-2 to Howard. She's an event planner, so she just had W-2 income. She would provide all the information to Howard and he would meet with their CPA. She would always sign. At this point, all she's signing is the e-file signature authorization page. She never really looked at the return and she never questioned anything. She assumed she should have filed a joint return because she's married, and she never questioned Howard about anything because he's the expert on finance. He's a businessman. Prior to filing for divorce, Whitney discovered that Howard was cheating on her with their babysitter. Out of guilt, Howard quitclaimed. They live in this beautiful residence in Bel Air, and out of guilt, Howard quitclaimed his interest in the house to Whitney, but Whitney never filed the quitclaim. Subsequently, Howard gave a quitclaim deed of his interest to his brother. So, and then finally, Whitney files her quitclaim deed. In the agreement that they have, that's so far in effect, Whitney was receiving child support and alimony, and because of the financial distress of the pandemic, Howard has been falling behind in his payments. He wanted to sell the house, the Bel Air house, but he couldn't because the title was very muddy. And so here we are. Whitney walks into Lee Moore's office to figure out what she can do and where she's at with her situation. So Lee Moore, please set the context for us in this divorce proceeding.
Thank you so much, Michelle. Hello, everyone. Like Michelle said, I'm Limor Mojdehi-Azad, and I'm a family law solo practitioner in Century City. And as you can see from the fact pattern, there is a lot going on. And because these issues are coming up for our client Whitney during the divorce process, it's imperative that everyone has at least a basic understanding of some key terms and the framework of the divorce process in general. So when a couple comes into your office with no prenup, California law will guide the division of assets and debts. So first we have community property, which is the earnings and accumulations of either party earned during the time from the date of marriage to the date of separation. Separate property is all of those things acquired before the date of marriage and after the date of separation, and those things that were gifted to the spouse and inherited during the time they were married. There's also quasi-community property, which definition is in the slides. Quasi-community property means all real or personal property wherever situated in any of the following manners: by either spouse while domiciled elsewhere, which would have been community property if the spouse who acquired the property had been domiciled in this state at the time of its acquisition, or in exchange for real or personal property wherever situated, which would have been community property if the spouse who acquired the property so exchanged had been domiciled in the state at the time of its acquisition. So we have community property, separate property, and quasi-community property that we're dealing with as far as the division of assets and debts for the parties. You can also always change the characterization of property by transmuting it. A transmutation, which we'll see, is what Howard attempted to do. At least our argument as Whitney's attorney is that he attempted to do with the quitclaim to Whitney after he felt guilty for cheating on her. So a transmutation of real or personal property is not valid unless made in writing by an express declaration that is made, joined in, consented to, or accepted by the spouse whose interest in the property is adversely affected. Another key phrase to remember and concept is commingling. If a party commingles their separate property funds with community property funds, that could change the character of the separate property. So another key term to remember is date of separation. So the date of separation means the date that a complete and final breakdown in the marital relationship has occurred, as evidenced by both of the following. So the spouse has expressed to the other the intent to end the marriage, and then the conduct of the spouse is consistent with the intent to end the marriage. There are a lot of arguments to be made as far as conduct, which I also understand will be a key element in the bankruptcy issues that arise. So there are a lot of arguments to be made. And for this purposes of this fact pattern, the basic framework of the divorce process, just in general, is crucial to understand. So once one party is filed for divorce, the summons is issued, which contains pre-printed automatic temporary restraining orders, which family law attorneys just refer to as the ATROs. They're the standard family law restraining orders. And they basically say that without the consent of the other party or a court order, neither party can do specific things. There are a multitude of things that they can't do. Included in that list is that they cannot remove minor children from the state. They cannot dispose of property, change beneficiaries. So in this example, when Howard attempts to sell Bel Air, even though the title is muddy, that would be a violation of the ATROs. And we'll get to the breach of fiduciary duties later on. But that's a key element of what is going on here between Howard and Whitney. Once the summons is issued, within 60 days, the parties are to exchange what we call their preliminary declarations of disclosures, or their PDD. Within this disclosure, both parties are to disclose to one another their income and expenses and their assets and debts, along with 2 years of tax returns for the 2 years prior to filing and serving these documents to the other party. Now, here we can see that Whitney in this fact pattern is really surprised by all of these assets that Howard had and the way he handled the assets during the marriage. So we're going to assume that Howard did not disclose that these things existed during the marriage, but during the disclosure process he did, which is, often surprising. If someone has a Swiss bank account, they probably will not disclose it, and you will have to go through a lot of discovery to maybe find those types of assets out. Once both parties disclose this information, that's the time where your attorney will look through the documents and see What type of discovery do we need to do? Are we able to settle issues with the other party, or do we need to obtain court orders? So here we see that in 2019, Howard was ordered to pay $15,000 in support, which is a high support amount. And now he's making excuses that he's behind on support because his business has gone down. And of course, I say it's an excuse. It's happened to many, many people. But what Howard should do, and what I think that he's going to do, is to file for a modification of the support. Now, child support and temporary spousal support, which is spousal support that's ordered prior to a final judgment, can be based on the DissOMaster calculator, which is a software that family law practitioners and the court use to determine support amounts. Now, that software takes into account the entire code, and which includes timeshare for visitation, number of tax exemptions, tax filing status, and the income of the parties, along with a variation of other inputs you can put into the calculator. So I would anticipate that Howard will likely file a modification, and Whitney should watch out for that, because typically when your client is the one who gets furloughed, is not making the same amount of money, you would want to go in for a modification. Here, most likely, Howard's income obviously has gone down too. You'd have to do discovery to figure out what happened with the PPP and how he used it, to see if the modification, how it would affect Whitney. If her income went down and his income went down, you'd want to run a DissOMaster to make sure that you're not going in to get your client a lower amount of support.
Lamore,
Yes.
I'm sorry to cut in. In regards to modification, if he goes in and is successful lowering his payment, does he have to make up that amount later? Or it just, she loses that amount? So if he goes down, let's say $1,000 a month, does he have to make up that $1,000 later on when he's doing better, or she's just lost it?
No, so that's a good question. Either party is free to make a modification at any time the circumstances change. So if he goes in right now because his income's lower, and we get an amount under $15,000 for total support, and then later we hear that Soothe Me is booming, we would want to go in for a modification to get the now modified lower amount back up to 15 or hopefully more.
So it'll be up to her. Okay.
It'll be, yes, it's up to either party anytime the circumstances change. You know, for an attorney, it just depends on who is your client. Are they the payor, payee? What's going on financially for both of them? So now we can go into the other assets that are involved in this fact pattern. We have the LLC for Soothe Me. It looks like there are a lot of payroll issues that Whitney didn't know about. It seems like she had nothing to do with the business, but you'd have to do more discovery to figure that out, ask your client questions. Once we connect with Michelle, we'll also learn what other key information we need to discover in this process that might be helpful later. And as you can see, we need a lot of professionals in this fact pattern to help Whitney. So, you know, White Zuckerman as forensic accountants, perfect for a case like this. We have Soothe Me. We'd have to value the business. We want to know, when was the LLC established? Is it all community? Is it partially separate property, but then Howard may have used community property earnings that he earned during the marriage through the date of separation to continue to fund Soothe Me? You'd have to figure that out. Then we have the issue of the Swiss operations. This is, you know, sometimes when you see operations that are not within the United States, the reason they were created might have been to conceal the asset. But Howard is being very forthcoming in his disclosures. Obviously, it looks like there is one Swiss account that was inherited. So he's most likely going to say, that's my separate property. Again, we need tracing to figure that out, because the assumption is going to be everything is community property. And if you have an argument for a separate property asset, the burden is on you to prove that. So that then takes us to the quit claim. Whitney's argument might be the family residence is 100% mine. Howard wrote in this quit claim, we have an express writing by the adversely affected party that he is giving me his interest in this property. Now, why Howard gave his brother an interest, we don't know, but if he brings that up, that most likely that house will, the issue of the house probably will go to trial. But you can make the argument that 100% of that property, because of the quit claim, is now Whitney's. Not sure what Howard's arguments are going to be, but the brother thing is going to be an issue. The title is going to be an issue. And then we have the LLC, the quit claim. And then within this fact pattern, we basically have a multitude of breach of fiduciary duty issues. You can see from the PowerPoint, fiduciary duties in a marital relationship are not unlike fiduciary duties that business partners owe to one another. So you can see from the slide under Family Code Section 721, this confidential relationship, the marital relationship, imposes a duty of the highest good faith and fair dealing on each spouse, and neither shall take any unfair advantage of the other. Now, the specifics of the fiduciary duties and possible consequences are on the slides, but when you have someone who's attempting to sell a residence without the consent of the other, that's a violation of ATROS, possible violation of breach of fiduciary duty. Someone who was not paying tax, payroll taxes, someone who had accounts that the other spouse did not know about during the marriage, depending on what he did, if it adversely affected the community, and now Whitney may or may not walk away with less than what she would have had Howard been forthcoming, had he taken care of these assets during the marriage. Then you have breach of fiduciary duty issues. And I think in Los Angeles, what we see a lot is that the dynamic between two spouses is that one has taken over the finances and the other one doesn't really know anything about them, but they'll sign a joint tax return because it's beneficial to both of them, but they won't really review it because they've hired that responsibility out to a CPA, and it's kind of the responsibility of the other spouse within the marital dynamic. You see that a lot. But when issues like the ones that Howard has brought to us, and he's making a threat of bankruptcy and tax, you often have a spouse who's already gone online and they come to you and they say, well, I'm an innocent spouse. I'm an innocent spouse. I didn't know anything about it. And that happens a lot. And that's when you want to call on someone like Michelle to tell you, when does that come into play? What are the issues that we need to look out for? So you can make sure that within the discovery process and within your declarations for your client's testimony, and anything else that is filed or disclosed in your case is not contrary to possible arguments for innocent spouse. And Michelle can go through that in more detail.
Oh, okay. So, I'm going to pick up where Limor left off, and I'm just going to go through some of the tax issues that we have going on here. So, in the first paragraph, we look at how Howard owns and runs Soothe Me. There's no indicator that anybody else is a co-owner. And he has a bunch of employees and he forgot to pay or didn't pay payroll tax. So the question one might want to ask is, why would the IRS file a lien against Howard personally with respect to Soothe Me's payroll tax? Isn't it a corporate liability? Well, not always. So what happens is, if a company is not able to pay their employment tax, the IRS will try to find someone who's called the responsible person, and that person will end up having personal liability for the payroll tax. So a responsible person is someone who willfully fails to collect or pay employee withholding. The usual situation where I'll see this is with a company that was in financial distress, and what'll happen is the owners will come in. It's usually the owner who ends up with this responsibility, and they'll say that they were paying other debts. Now, I just want to back up for a sec second and go over who is a responsible person. So it's the person who had the duty to perform and the power to direct the collecting, accounting, and paying of trust fund taxes. What is the trust fund tax? Let's back up and think about what that is. So when a company pays their payroll tax, there are different elements of it. The trust fund portion is the amount that they have withheld from their employees, and they are supposed to pay over. So when they, the way it's viewed is when that money is withheld, they have now assumed a fiduciary relationship with respect to that money, a fiduciary relationship to the taxing authority, either the IRS or the EDD, to pay it over. And if they fail to pay it over, they've breached that duty, and that's how they end up with personal liability. So they now, so usually the person who is tagged with personal responsibility, and the IRS does a whole interview to figure out who it is. Is it someone who has control over financial affairs and discretion to decide who gets paid? It's not the person sitting in a cubicle actually writing the check, but the person who makes the decision about it. And so it looks to us like Howard would fit into that description. And usually if what happens in most cases is that they're paying the business debts, they're paying rent, they're paying their workers, they're doing what they can just to keep the business alive, they'll most likely, the worst thing that will happen is they will have this personal responsibility. And in the slides, I go into more detail about it. However, if it's a very large amount, if it's over multiple periods, if the taxing authority discovers that in fact the person who was the responsible person was using company funds for their personal reasons, well, now you might be looking at criminal liability. The IRS has gotten more active in this area. They've been enforcing employment tax a lot more, and they I have also picked up on criminal liability for employment tax. So it is something that needs to be thought about and made sure that you comply with it. So in this situation, Howard now has a lien filed against him, and the way the lien works is it's not filed against the property as some people think. It's actually filed against the Social Security number of the person who has the liability, and then it goes across to any property that they hold. So in this situation, it is on Howard's Social Security number, and unfortunately it's on that house. And so I think Sanaz will discuss a little bit more about how that will play out in bankruptcy. Regarding the PPP loan, we don't know yet if Howard has applied to have the loan discharged. You know, if he used the proceeds properly pursuant to the rules, what did he use it for? If it was discharged, he now has tax-free income for federal purposes. He has taxable income for California purposes, but it is some additional money that maybe, I don't know, Limor, I would think perhaps Whitney would want to look at to see if there's some more money coming in to soothe me, maybe it helps with the valuation and so on. So a big issue here also is this Swiss bank accounts. And while this can easily be the subject of multiple CLEs, just to discuss the foreign reporting penalties, as many of us know, you know, if you have a foreign account, if you're a US citizen or resident, you need to file FBARs, foreign bank account reports, every year regarding those accounts. And of course you need to report the income from those if there's any income, interest, or whatever it is, or obviously your foreign operations. And if you don't file those FBARs, you can be hit with some pretty hefty penalties. And that has been the FBAR penalty enforcement and litigation has been somewhat active recently. The IRS has really stepped it up, and a lot of these cases now are working their way through the courts. And so, you know, Howard hasn't done any of this, and he needs to think about filing these FBARs, and he himself should consult with a tax attorney to figure out what is the best way for him to go about it. If the IRS has not yet examined him in any way with respect to this, with respect to him personally, he might be able to do some sort of voluntary disclosure to be able to minimize the penalties that can be asserted against him. Since he had, and there are 3 different ways that you can do a voluntary disclosure, and I'll run through it super quickly, but it really should have a lot more time, and it's in the, all of this is in the slides that I've provided. But you can, if there's no income tax due, you can try to do something called a quiet disclosure, which is you just file the FBARs and put a small description in your FBAR explaining why it's late and hope that you'll be good. There's something called the streamlined procedures process. Oh, and then I should talk about willful versus non-willful. If you were non-willful, the civil penalty that you would be charged with is $10,000 for each non-willful violation. Now, previously, the IRS had been asserting that the $10,000 is per account. So for example, if you have Howard with these multiple accounts, potentially it could be $10,000 per account per year. So he's looking at $60,000 per year. There's a recent case that came down in which the court found that it's not per account, it's per FBAR. So it is $10,000 per year. That's a very nice result for taxpayers. It's not in the Ninth Circuit, but we'll see that litigation is still pending. If, however, you're found to be willful, the penalty is the greater of $100,000 or 50% of the balance in the account at the time of the violation. So the first thing that Howard would need to try to figure out is whether he has a willful or non-willful violation, and then figure out how he can best try to help himself in this situation. If he's truly non-willful, he can do this, what's called streamlined procedures package, where he would file 3 years of amended tax returns and 6 years of FBARs, do a whole presentation on why he has what's called reasonable cause for his failures. And what he would end up having to pay is a 5% of the total amount that is in his account. And he can move on, and now he's just in the system and he has to file FBARs going forward. Now, if it looks like he's willful, or worse yet, maybe there's something potentially criminal going on, I don't know enough facts yet to figure out that, he might want to think about doing going into the voluntary disclosure program. The penalties are much heftier, but it should absolve you from criminal liability. But that is something you really need to have tax consultation for, and figure out, do you really need to get involved with such a hefty penalty, or can you really prove that you have reasonable cause? Now, in Howard's favor, you know, he is, so when people hear Swiss bank accounts, it makes people nervous. Oh, it was, he was trying to hide something, but he's Swiss and his business is in Switzerland and his accounts are in Switzerland. And the reason why I'm mentioning all this is because if you have a connection to the country that you can show, and there's a reason why you would have an account in that country, you have a better shot at being, you know, shown to be non-willful. Maybe you were stupid, but you weren't willfully trying to hide an asset. This frequently comes up when I have people come into my office who are immigrants and they lived in a separate country, they inherited something, or they had some business operations there, and previous not so astute accountant ignored the fact that they were from a foreign country and just never questioned them about it. And then really good new accountant discovers this information, has the presence of mind to ask this person if they have anything in a foreign country, and then they end up coming to my office and I'm able to put together a package. I've actually, every time I've done this, it's been successful. They pay their 5% penalty and we never hear from the IRS again. But again, you need to figure out exactly what did they do and what's going on here. And another thing, Limor, I just wanted to ask you is one thing I have, another thing that's important also before I ask the question, Limor, is one thing to look at is what is happening with these business bank accounts. Did Howard somehow give Whitney some kind of signatory authority that she didn't know about on these accounts? Because if that's the case, while it might help her family law case in terms of what's a community property, she now could be considered someone who is liable for this penalty, penalty. And there's a recent case that has come up. It's not quite resolved yet, but there was an issue with someone whose wife was a U.S. citizen. They didn't live in the United States, and he had some signatory authority over these accounts that he never had anything to do with the United States at all, and he's being tagged with these penalties. So she needs to figure out what's going on. And another thing often that comes up that I have found, and it can be in somewhat relationships that, I don't know if you call them abusive or inequitable, where, one of the spouses signs a whole bunch of things and doesn't realize what they're signing up for. And suddenly, a business they had nothing to do with, they suddenly are the responsible person for employment tax. I currently have a case with someone who is responsible for a lot of sales tax on a restaurant that her husband opened a restaurant. He had a DUI. So she signed all kinds of things so they could get a liquor license. And now suddenly she's being, charged with personal responsibility for sales tax. So people need to really watch out what they're signing up for. But one thing is, I would always ask the family law attorney is like, let's find out what she signed up for. It's almost like people need to know this before they sign up, and they don't know what they're signing for. So I would be curious to know if Whitney is on any of the signature cards for this account. But Limor, what happens here? Let's say Howard, I would think first we need some forensic accounting to trace out and figure if anything is community property. But let's say the business income is community property, but because Howard didn't file these returns, he ends up having to pay this 50% penalty. What can Whitney do anything? Because perhaps, she's now losing some of this community property because he failed to pay his taxes. So how does that work?
Right. So what I would try to do is either negotiate with the other side to ensure that she is not responsible and use that agreement as a shield when the IRS comes after her, which likely wouldn't happen. I mean, I don't think that Howard would just sign off on that unless our facts are really, really strong. But again, I would make a case for breach of fiduciary duty. I would make a case for relief in the amount that now Whitney will potentially be responsible for, so that she doesn't lose out on that money because of Howard's irresponsibility and concealment of the issues.
All right, so that's an issue. And then the one last thing I'm going to talk about briefly, and I want to be able to turn it over to Sanaz, is the innocent spouse issue. So, what's going on here is it really looks like Whitney didn't have much to do with Howard's business at all. In fact, she didn't even know about his Swiss business. They live in a beautiful house. One question is, you had to have known that there was this income because of your lifestyle. But if the Soothe Me spa was really successful, then Whitney could potentially argue that based on that business, she had every reason to believe that Howard could fund her lifestyle. So that is a question, is lifestyle. But an innocent spouse situation, innocent spouse is a collection defense. So what that means is the first portion when you're dealing with the IRS is you need to figure out how much do you owe. So I look at it as a continuum. So over here is the examination portion or the audit portion, filling out your tax returns, and all this is going through until you hit this moment where your liability is assessed, and that the assessment will take place generally, when you file your return, whatever you file on the return, and then if there's an audit, that amount. Now you have an assessment. Now the liability has been created. Once the liability is created, that's the first moment that you can think about innocent spouse. And once the IRS sends out the first notice regarding the liability, the person who wants to claim innocent spouse is 2 years to claim it. So to be able to do that, the liability must be from a joint return, and the spouses must be separated, and the IRS has a form that you fill out. And then what the innocent spouse wants to show is that she or he, that the spouse had nothing to do with the business. You look at the facts and circumstances. If there was abuse in the marriage, that can be documented with police reports or restraining order. That's helpful to the innocent spouse situation. You might want to have declarations about the fact that, from the other spouse's business partner saying the person claiming innocent spouse had nothing to do with the business. And it's a factual discussion, and you hopefully can get yourself resolved of tax liability. And so with that, I want to turn it over to Sanaz to inform us about all the bankruptcy matters that are going on here.
Thanks, Michelle. I'm Sanaz Barliani Law Firm. I've been practicing for about 12 years now, and I do debtor and creditor work. So today, I'm going to focus our talk more along the side of creditor representation inside of bankruptcy, although I'll touch upon debtor representation as well. In this scenario, Whitney would likely be a creditor of sorts in Howard's case. She's going to be looking to see if she finds holes in the case to bring up to the trustee, ways to protect herself against his bankruptcy filing. First off, Howard informing Whitney that he may file for bankruptcy. I take this more to be a threat because just looking at the fact pattern, he has a lot to lose. But even though, you may doubt that your client, actually Howard would be filing for bankruptcy, it's always good to consult with a bankruptcy attorney, make sure that your client is protected just in case he is serious. So here, if Howard actually files for bankruptcy, and Whitney comes to me for that, I would basically want to review the petition with her. Just like Lamore mentioned about disclosures being important in family law, they're very important inside bankruptcy as well. Howard would be signing the whole petition under penalty of perjury. He'll be testifying under penalty of perjury at the 341A hearing. So you want to make sure the information that is disclosed is correct and complete, and along the lines of what's in the divorce paperwork. So inside bankruptcy, on Schedules A and B, Howard would list his assets. So there I would expect to see Soothe Me listed, the Bel Air residence, the Swiss assets, and I would go line by line with Whitney to make sure everything is listed on there. In regards to Soothe Me, is that a concern of him filing bankruptcy? Possibly. I may not be the most concerned with Soothe Me because if it's got a lot of debt, tax liens, payroll, credit cards, business loans, there may not be any net value left over for the trustee to liquidate. When a Chapter 7 bankruptcy is filed, the trustee's duty is to look out for the creditors and to make sure that if there are any assets, they can be liquidated to take care of the creditors. So here, Soothe Me would be liable inside this bankruptcy, or would be an asset inside this bankruptcy to the extent that Howard has an interest in it that can be sold, liquidated, and paid off to the creditors. So that's one concern. Whitney, unfortunately, even though she has a community property interest in this, cannot tell the trustee, do not touch my 50% share of the community. When the trustee steps into Howard's shoes, he has the ability, or she has the ability, to liquidate the whole community interest. So that means he can liquidate Whitney's interest in Soothe Me as well. I'm not the most concerned about that one, so we'll move on. The next one is the Swiss assets. Inside bankruptcy, you list the assets on Schedule A and B, but you have to exempt them. You have to protect them from the trustee's liquidation on Schedule C. Under wildcard, which is 11 USC 703B5, you can protect approximately $30,000 in cash on hand. So I'm assuming that the money in Switzerland is a lot more than $30,000, or in a combination of monies he's got in the US plus Swiss plus interest in the business and whatnot, it is a lot more than that. So the trustee will likely want to go after these Swiss bank accounts and the Swiss business operation and liquidate it. Again, this is not something that Whitney can protect her portion of the community in this. But one of the things she can do is she can possibly choose to purchase her interest back from the trustee. So trustee, yeah.
I don't mean to interrupt you, but I'm interrupting you to ask this question. And it's also a question for Michelle. So as the divorce attorney, if these things are coming up, do you recommend, because it will protect my client, to take the issues to court and obtain a judgment or a settlement between the parties that protects her interests within the family law court, because she can then use these things against the bankruptcy court and use these agreements to show the IRS that these assets are protected, they're now hers, go deal with Howard stuff? Or am I just wasting my breath trying to negotiate assets for her, because later on, because of what Howard has done, the IRS or the bankruptcy trustee is just going to come after the asset no matter what we classified it as or ordered it to be pursuant to the family law court?
That's a really great question. The bankruptcy trustee will look at the divorce documentation, the judgments, and all that. But they don't necessarily have to go with that. If, for example, and we'll get this at the bottom, but Howard felt guilty and claimed the property, the Bel Air residence, to Whitney. Even if you were to go to court and get a judgment, get the family law judge to sign off on that, the bankruptcy trustee can undo that transaction because there was not enough consideration paid. It wasn't fair that she got so much of the assets. Also, they're looking out for the best interest of the creditors. So if it looks fishy that he transferred this big asset to his ex-wife on the eve of bankruptcy filing, and I would consider transferring real estate within the last couple of years, even at the eve of bankruptcy filing, because they can go back that long, even I've seen 3 years, to undo transaction if there's not enough consideration or it just smells fishy. So you may be wasting your breath, but you can make the argument of it is equitable and there has been consideration paid. Now, tax-wise, I don't know what, Michelle, do you want to chime in on that part?
Yeah, so are you asking about, for example, like the tax lien that's filed against Howard, what happens to Whitney's portion of the house or thing? I mean, is that what you're asking about? Or
what I'm asking is, for example, in a lot of family law judgments, we will say that one party can include a child on their tax return as a dependent, even though by IRS rules, they didn't have the majority of custody of that child. So we'll put in our judgment something that says father is able to claim the tax exemption for both children, right? But that's just a family law judgment that says that if he's not following the IRS rule and not actually filling out the document that releases, mom is not filling out the document that releases the exemption to her, it doesn't matter. You can maybe go into court and say, I didn't get the tax exemption, he beat me to it, she beat me to it. But if we get orders, if we have the other party signing orders that holds the other harmless, indemnifies them because of a liability that the IRS will come after them for, will that actually protect that spouse? Or is the IRS just going to come in and say, it's nice that you have that, but these are our rules?
So the IRS is just gonna, if they conducted an examination, then they would just say, that's nice, that's between them, but this is what the rule is. That's the most likely outcome.
Okay.
But could depend, maybe facts and circumstances can change it, but most likely they'll just follow what the rule is and say they need to work out their liability amongst themselves.
Got it.
Okay. So going back to the bankruptcy realm. So disclosures and looking over the schedules with the attorney is really important, because you need to pinpoint if there's assets you know of that have not been listed on the schedules, or the values are not correct that have been disclosed and exempted. So this takes us to the next step. A month after the bankruptcy filing, there is a 341A meeting of creditors. It's an informal meeting with the trustee. It's a public meeting where other people can be at as well, but it's the opportunity for the trustee to meet the debtor under penalty of perjury, ask questions and see if there's any assets to flush out that can be liquidated, and make sure everything is on the up and up. So Whitney plus her attorney, let's say me, can show up at this hearing, and this will be our opportunity to ask questions after the trustee does. So if we know for a fact that there were certain documents that Lamore told us she found and they were not listed on the bankruptcy petition, we can bring that up to the trustee. We can ask the debtor, Howard, those questions and try to get to the bottom of it of, were there more Swiss assets that were not listed? Was the value of Soothe Me much higher? Did he take draws that he did not report? Anything, really. So it's really important to look at the disclosures and make sure, or the schedules, make sure everything is listed, to communicate with the trustee if there is not anything. And then also, if there are assets the trustee is interested in liquidating, but Whitney wants to keep, that would be her opportunity also to reach out to the trustee to buy back her interest or to buy Howard's interest in that asset so she can keep it for herself. So this bankruptcy would not be a total loss for her. Now, I'm going to skip the tax issues. I'm going to leave that wholly for Michelle. And whenever I see tax issues, I refer to a tax attorney like Michelle because my knowledge for tax is limited and I don't want to misguide. Some taxes can be dischargeable. However, in this case, if it's mainly business taxes, I don't think they're going to be dischargeable, but I'll leave that to Michelle to talk about. If it was income taxes, they could be dischargeable if it is older than 3 years, if it was filed more than 2 years ago, and there's been no audits or assessments in the last 240 days. So I usually ask for a tax transcript. I'll do a cursory review on it. If there's any gray lines or any bigger issues, then I send it out to Michelle, have her tell us whether they're dischargeable and whether we should file now or wait a few months to file. Now, in this case, since Howard's the one who is filing, if she has any liabilities on the taxes and they would have been discharged for Howard inside the bankruptcy, it's not discharged against Whitney. Whitney can still be liable for those taxes if she would have been liable before. So that's something to consider. Tax issues don't necessarily go away against her. What I want to jump to is the property. So Whitney received the quitclaim. Whitney recorded the quitclaim. The trustee can very easily undo that transaction, the quitclaim, and bring it back to the community. So by quitclaiming the interest to Whitney, he's technically trying to take it from the community property form, let's say, to make it her separate property. If there hasn't been consideration, or like Lamore, your example of you got a judgment inside family court that said this is 100% Whitney's, the trustee can undo that transaction because it belongs to the estate. It was not fair for her to get all the assets. There was no consideration for it. It was not equitable. So that's one problem she has. Recording the quitclaim doesn't mean anything. Him giving the quitclaim to the brother doesn't necessarily mean anything. The trustee will look to sell the property if there is equity available after any mortgages, any tax liens, and possibly any homesteads. And that's another thing we need to find out is there any homesteads, on the exemptions on Schedule C, did Howard list and protect at least $100,000 of equity in the property? So that's something to consider. And if the trustee is looking to sell this, which I think a Bel Air residence is definitely going to have a few $100,000 of equity, is Whitney able to and willing to negotiate with the trustee and keep the house by paying off the trustee and buying back the equity in the property? So those are the major ones. Now, there's two other things that I wanted to bring up. One is proof of claim. So it would be important for Whitney to file a proof of claim if she is owed monies. So for example, here there's domestic support obligations owed to her. He has fallen behind on the support payments. Hopefully he's listed her as a creditor on his Schedule E so that the trustee and the court knows that she's a priority claimant. but she should also file her proof of claim. If he lists that, for example, he only owes her $5,000, but in reality, he owes her $15,000, she should file a proof of claim showing that her claim is higher, so she gets paid her correct amount. And two, if there's a real dispute between the amount of domestic support obligations that are due, I would even recommend for her to file an adversary complaint against Howard to have the domestic support obligations be determined to exist, the amount, the validity of it, the amount of it that's due to him and also to her, and also the fact that it's not dischargeable. So if he ever goes back into family court and tries to argue that I don't owe her money, that there is a bankruptcy court who has reviewed this and said it's not dischargeable, that it is actually higher than he claims. Oh, kind of help her to do that. And then let me see what I wanted to touch upon. There was one last thing I wanted to touch upon was in regards to the divorce. If Whitney, let's say she magically met a guy during the bankruptcy and wants to get married, and she doesn't want to wait for the bankruptcy case to finish because there's going to be assets that are liquidated and it's going to take about a year or two, and she wants to just move on with her life, then I would recommend for her to file a motion for relief, basically letting the court know that she wants to go back into divorce court, family court, and bifurcate the case and finalize the divorce so she can remarry. So, and Lamar, if you want to touch upon this, she can bifurcate it and leave the property settlement to be taken care of later after the bankruptcy is done. But for right now, finalize the divorce so she can remarry someone else and move on with her life. That is something that is.
No, that's a great idea. She can do a status-only judgment that would restore her as now a single person, so she can move on with her life, and we still have the issues of division of assets and debts and all of those things that we will deal with separately.
One thing I want to touch upon is regarding support that I was talking about it. That's something that is never dischargeable. So it will always be owed, even after bankruptcy, even if she doesn't receive any money through liquidation in a bankruptcy case, even if it's 10 years from now, she'll still be owed that money. But you just want to make sure that the disclosures in family court and the disclosures in bankruptcy court match up. So to the extent that there's things not listed in the bankruptcy, I think that'll help Lamar possibly to say, he signed this under penalty of perjury. He didn't say that she owed him any money. So I'm going to assume that Whitney doesn't owe him any money, for example. So you just want to make sure that things match up to make it smoother for the divorce and to protect Whitney the most.
So now we have a question. So someone is asking, are you saying the division of property in a divorce does not constitute consideration as viewed by the bankruptcy court?
Typically, each spouse is owed 50% community when they divorce. If Howard simply quitclaimed the house to Whitney because he felt guilty, that's not consideration. If, however, she, out of her separate property funds, let's say, funded him to go to school to get a master's degree and helped improve the community and is owed an equalization payment back, monies back to her separate account, and then Howard says, you know what, me quitclaiming the house to her for the equivalent amount that she paid for my education, that would be considered consideration. Then she would be more protected. But it would not be consideration because he simply felt guilty. The trustee steps into the shoes of Howard and liquidates the community. So she needs to make an argument of why the community owes her separate account or separate property money, not just because he felt guilty. I hope that makes sense. And that's basically it at this point. I think it's really important for her to protect herself and also to call out his threat of bankruptcy. She can easily come back and say, I don't think you're going to file bankruptcy. You have too much to lose by filing bankruptcy.
Yeah.
And also, I didn't touch upon the other chapters of bankruptcy, 13 and 11. 13 is like a smaller version of a chapter 11. They're both reorganization plans. 13 has debt limits. And so given the fact scenario, I don't think Howard would be able to qualify to be in a chapter 13. And then chapter 11 is a reorganization plan, which may possibly be good for him because of the tax debt, the business debt, and everything, but it's very expensive. Starting retainers can easily be $50,000, filing fees are $1,700. And if he's having a hard time paying his family law attorney and domestic support obligations, I doubt he's going to afford to do a chapter 11. That's why I focus this as a chapter 7. And that's why I think that I'm hoping that he's smart enough or has smart counsel to advise him not to file for bankruptcy because he's going to lose a lot.
Okay, so I think, wait, there's one more question. In my experience, the trustee and her creditors will also look at the property division, keeping in mind the various clawback provisions available on you as well. Okay, I don't think this is a question. I think it's a comment, or do you want to respond to that?
I'm going to just comment on Mr. Walkowitz. Thank you for that. You mentioned that under section 362B of the Bankruptcy Code, you don't need bankruptcy court approval to bifurcate the dissolution proceedings and dissolve the marriage. I definitely agree with that. I've had the experience of having opposing counsel come back and just try to start drama by saying that I've violated the stay, and even though it's not correct, and try to file something against my client. So just out of precaution, I recommend doing a motion for relief, even though it's not necessary. I guess it really depends on who your opposing counsel is, if they're smart enough to not just leave file things. But yes, the rule is that you don't necessarily need it, but as a precaution, it doesn't hurt, I would say.
And there's one comment in the Q&A. I think it's bankruptcy related. I don't know if it's a comment or a question. I don't know if you want to respond to it.
Let's see. In my experience, the trustee and or creditors will also look at the property division, keeping in mind the various clawback provisions available under the Bankruptcy Code, as well as state UEFA. That's correct. Yes. So that's why just simple agreements that spouses have entered into on their own of how they want to divide property is not good enough. The trustee has many powers to undo these transactions and liquidate these assets for the betterment of the community, or the estate,
Right.
rather.
So I think those are all the questions. So I want to thank everybody for joining us today. If you have any more questions, contact information is in the materials. And I want to thank the Beverly Hills Bar, and I look forward to more programming from our 3 sections. And thank you, everybody, and have a wonderful afternoon.
Thank you.
Bye.
Bye.